So my presentation has slightly different focus from the three fascinating presentations that we had before, but hopefully that's also interesting. So I'm shifting my attention more slightly away from the political capture of the judiciaries and danger in that sense to more internal dynamics inside the judiciaries. And the question that I will be posing is, so what can go wrong if everything looks good on paper, if the powers are shifted from politicians to judges and the country follows all the templates and prescriptions of the European expert and consultative bodies? So under what conditions could formally depoliticized, judge-dominated institutional arrangements really become problematic? So the type of arrangements that are commonly recommended and associated with greater independence. There are two scenarios that I would be looking at. One is that of the indirect politicization or political capture through reliance on judges in positions of power. And another one, more importantly, the internal capture by what I call judicial oligarchs or influential judges that monopolize positions of power and acquire really very broad influence all across the system, judicial system. So this is kind of the combination of the two factors that we see at the example of Georgia. So if we look on paper, Georgia is really a good example of what needs to be done. It has a judicial council that has the majority of judges, and those judge members are, in contrast to Poland, for example, elected by judges themselves. And the judges themselves can nominate candidates. Also, Judicial Council appoints court presidents, and the procedures seem to be improving. It's more transparent. Now Council has to substantiate its decisions. So on paper, everything looks very well. Now the question is what happens in practice and how the law translates into the judicial behavior. So if we look at the timeline of the development of the Georgian judiciary, and with a particular focus on who gets to govern, who are the judges who that take these leadership positions in the council or as court presidents. So prior to 2013, Georgian Judicial Council was occupied by court presidents, essentially. However, the political change ultimately allowed adoption of new legislation, which opened up opportunities for participation of more rank and file judges. However, and then there was a very positive development of 3 years where judges that had been very, very passive for 10 years before started speaking out, started discussing, started forming associations, alternative ones, because prior to that there was only one judicial association. However, 3 years later, somehow everything became quiet more, and what we see is a really return back to the pre-2013 situation. So I will be probably asking, what are the reasons for this? What are the consequences, and what could be potential solutions in terms of how to dismantle this concentration of powers in the hands of very few, very influential judges? I will explain what I mean by judicial oligarchies at the example of the Georgian situation. So this is the internal capture of judiciaries by very few influential judges who then themselves hold positions as court presidents or members of Judicial Council, but also rely on the network of influential, loyal sort of allies, judges with whom they share professional and personal ties, and ultimately they managed to acquire the system-wide influence. So how it happened, what was contributing to this situation that these groups managed to occupy all leadership positions and then rotate over the years so that each of them has stayed in power for 10, 15 years, occupying these administrative or managerial positions. So the first was the careful court packing, where they tried to hire more people based on a loyalty to them rather than merits, or at least based on the low likelihood that they would challenge the status quo. So essentially, this was also facilitated by the fact that the lawyers from outside the system were not really interested into going into the judiciary and becoming judges, and there was less interest and discouragement as they saw what kind of practice the Judicial Council occupied by these judicial oligarchs was developing. And the second is already what happens post-appointment, and how, and these my observations are based on the analysis of many statements made by the leadership and the judicial behavior as well. So what we see is that really an encouragement of the passivity and deference on the part of judges, and these we see in all aspects, like, for example, with regard to the elections to the Judicial Council. While in the first few elections after the change, there were many candidates and they were competing. Right now, there are as many candidates as there are vacancies, and the judges basically accept the candidates that the leadership proposes. The same situation with the court president appointments. Judicial Council in a centralized manner appoints all court presidents, and then the whole consultation procedure that has been introduced by legislation is really merely a formality, and only one candidate is essentially ultimately approved. And then another aspect is that judges started leaving this alternative new association immediately when the issue of their reappointment was put on the agenda. So right now we are back to the one judicial association, and the other a new association established after 2013 has no sitting judges among its members. So essentially, judges are only proactive when they need to speak out in the interest of the influential judges. So the second element is then the monitoring already. So basically, court presidents are mechanisms of monitoring the judges' behavior. So if they deviate from this expectation of passivity and deference, there are informal sanctions. They are rare because judges do follow the rules, but they happen. And then also misuse of formal mechanisms. I guess this has been applied a lot in Poland as well with disciplinary measures. But in Georgia, mostly they are not necessary because they already refused reappointment to most active judges, so they are no longer part of the judiciary. And ultimately also the safeguards don't really work. It's absolutely useless to go to the courts to challenge the Judicial Council's decisions. So there are two main reasons why this happened. The first is a lack of political will to consistently promote emancipation and empowerment of judges. So while there were some positive changes in the legislation, the politicians apparently realized that they would be better off if there was more centralized judicial governance with one group firmly in power. So they essentially left the provisions that helped sustain judicial oligarchy intact. These are provisions that allows the Judicial Council to appoint court presidents, and also the provisions that allow combination of several positions, holding the position of the court chairperson and also the position of the Judicial Council member. And also there were delays in imposing legislative constraints on the council as well. However, more important was that there was limited support inside the judiciary for changing the status quo. When I talk to judges quite often in the interviews, anonymous ones, they sometimes say we cannot expect judges to be heroes under this situation, especially as many judges were dismissed because of being active and courageous and kind of trying to compete for the positions and trying to sort of express their opinions about the practices of the Judicial Council. So the result is that the law, whatever we introduce into the law, might not really work because judges are not really willing, majority of them, now almost everybody, they are not willing to really use those opportunities. And this is understandable this happens for different reasons, starting from fear of losing their jobs to the fact that they are not really trained to speak up and mobilize. They are not used to it. In addition, they are not also as well organized and tied together as the dominant network, which is very close-knit and very well organized and structured. So what are the consequences? I will just list very briefly. So judges are silenced. There's no discussion. There are no judicial associations. Only the ones that are approved by the influential judges, like Women's Association, which is very narrow, which has very narrow focus. And as a result of this, there is very limited internal accountability for judges that hold these positions. They stay in power anyway, so they don't feel like they need to do quality work. And so there is no accountability through conference of judges or through courts. There's having analyzed all the decisions against in the cases where the council is a party, basically there's no way of winning a case against the Judicial Council in Georgian courts. So now there are a few cases at Strasbourg court, and it remains to be seen how this develops. So there's limited external accountability, as all the power has been placed in the hands of the judges, and the processes are seemingly transparent. However, most of the decision making happens behind the closed doors. So many judges, as well as non-judges and experts, think that it's the public part of it is merely performance, and that's put up for the public, and essentially decisions are made elsewhere and very differently. And this situation in its entirety, a concentration of this much power in the hands of the influential group, then leaves judges very, very vulnerable to case-specific pressures from judicial oligarchs. They have the possibility to make sure that the right judge gets the case. However, they may be inclined also to pressure whoever judge gets the case through automatic assignment. Or so essentially what we get is the more autonomous judiciary, which decides internally a lot of the issues that are related to the judicial careers, but without independent judges, without the judges that are not willing and able to speak up and express their opinions or compete in elections, etc. So what are the solutions under such situation? So there are probably two categories of solutions that we might consider. The first category is the legislative changes, so continuing and being more consistent in terms of the legislative change to create a more favorable environment. This could take a different shape. The first would be to disperse power between several governance bodies, so that capture of one body doesn't mean that you take control over the entire set of judicial careers. Right now, the model that is existing in Georgia is a strong judicial council model, where essentially almost all powers are vested in the Judicial Council. There are other bodies, but their members are also selected through the same conference of judges and following the same patterns as the members of the Judicial Council. So essentially the oligarchs have control, judicial oligarchs have control over those other bodies, as well as the judicial school and its governing board as well, even though recently the measures have been taken to increase autonomy of the school, and no longer, the council no longer is responsible for admission of the school sort of attendees, the future judges. The second would be to facilitate redistribution of power within judiciary and creating more opportunities and supporting more bottom-up governance and less centralization. For example, by way of letting judges elect court presidents, even though I wouldn't be very optimistic about this, because Ukrainian experience shows that essentially once judges were given that power, they also picked this very same judges as were previously in power, Yanukovych time court presidents. So more difficult, but probably more long-term important, requiring more long-term important investment would be the behavioral changes, and those, and what I mean under this is developing a judge's capacity and encouraging them to engage in governance more actively and meaningfully. So there would be two dimensions in that. One would be that they making sure that they use opportunities provided by law, like the right to nominate candidates. And another would be pushing for new informal norms that would complement those legislative changes, normalizing competition, normalizing asking questions, normalizing more discussion internally or publicly through judicial associations. So now the question is whether we can manage this under the current structure and current institutional arrangement, or one should go through more radical measures of some sort of judicial cleansing. I would rather stay under the current kind of would explore the possibility of really looking for in the sitting judges and developing their potential, and looking for like potentially the judges that could give example to the other judges in terms of speaking up and being proactive, even though it is risky. And I can understand when judges say that judicial, we can't expect everyone to be a judicial hero. Another would be to diversify judiciary and attract lawyers with more diverse experiences, so that there is a change in the dynamic. Right now, almost 90% of the new recruits are either former judicial assistants or former judges, so they are very much socialized in the current system. And then the question is who should select those judges, and whether it's justified and appropriate to really engage experts or the civil society as a way of oversight measure, or increase general public engagement, because in contrast to Poland, we don't have the demonstrations in support of independent judiciary. Unfortunately, it is only very narrow civil society groups that care about the judiciary. And now I think it was very much inspired by the Polish Court Watch that we're trying. There's a new NGO that's trying, based on the same model, to basically secure monitoring and engage more people as volunteers, so that public gets more engaged and interested. So it's very much inspirational example in many respects with Poland. So yes, quite a good example in terms of judges' proactivity as well as the public engagement in that regard. So I'll stop here. If there will be any questions regarding any aspects of my presentation, I think it's better to leave time to for the discussion. Thank you.